Hi there, I'm attorney David Drewicki, and today we're talking about mitigation. Now, it's a term that's thrown around a great deal during the course of a criminal case, and I think it's oftentimes misunderstood exactly what it is and when it comes into play and why it can be important. In simple terms, mitigation is just good stuff about you, the defendant, or about a loved one. These are positive things that can be shared with the state's attorney during negotiation or can be shared with the court prior to sentencing. There are formal bits of mitigation. There are things that are actually outlined by statute. And in Illinois, the different things the court is allowed to consider in mitigation is actually outlined in a specific statute, and that's ILCS. ILCS is the Illinois Compiled Statutes, or the laws of the state of Illinois. That's 730, Section 5 slash 5 dash 5 dash 3.1. So if you wanted to look that up and actually read every one of the mitigating circumstances, you could do that. But mitigation in a more general term, again, are those positive things about a defendant, about someone that's been charged with an offense that we can share to get either a reduced charge or a reduced sentence. So again, what are those bits and things that we can share with the state's attorney that are good? Typically, it's first and foremost looking at someone's criminal background. How extensive is that background? Is this the first time they've been in trouble, or have they picked up a number of felonies and misdemeanors in their past? We can then look at the underlying offense, what they've actually been charged with. You know, is this a crime of violence, or are we talking about property damage or monetary damage where somebody might be out money, which is still a crime, and that's unfortunate, but nobody was hurt. Nobody went to the hospital. No one's going to suffer long-ranging consequences with being injured. And that's another mitigating circumstance. Then there are just those things about the individual, about the defendant. Are they employed? Where are they in their education journey? You know, have they earned their high school diploma? Have they earned a college degree? Do they have special certificates? Are they currently in that type of programming, showing that in the future they can be a productive member of society, that they're going to be employable and are going to be productive? Those are good things that we can share with the state and with the judge. Sometimes it's just outlining what happened on a specific day, that it may still be a crime. It may not have been the best way of handling the situation. However, there's an explanation. Hey, this is why the defendant did this. Here's the backstory. Here's the history between the parties. If there happened to be more than one person involved, or there was a fight, or there's some sort of injury. It's like, this is the history between these parties, or showing how the victim, in the eyes of the state, really is someone who played a role in this case and maybe, but through some luck, aren't charged with a crime themselves. Sometimes we can look into something called restitution, where if somebody is out money, monetary damages, the defendant can pay them back. Say, well, you know, I damaged your property, your car, I maybe slashed tires or broke a window, or maybe caused some sort of medical expense to a victim, and you're reimbursing them because they're out of pocket, they've been damaged in that way, and you can pay them back. I mean, literally pay them back in terms of money. When we look at someone's background again, is this an isolated incident? Can we argue to the state's attorney or to the judge and say, listen, is somebody having the worst day of their life? They made a mistake. This is not something that's likely to repeat itself. You're never going to see them again in court again, Your Honor. This is why you should cut them some slack or give them the reduced sentence or charge. And then another common one that we run into is that it was just a really unusual situation, that it was unexpected circumstances. This is why someone perhaps stole some property or went into a store or into a marketplace and stole food or some other type of product because they had just lost their job and they didn't have the money to do it. They know it's wrong, but it was an unusual set of circumstances. And there certainly are others when we get into, again, just getting to know the defendant a little bit better. Let's learn more about their family. Are they married? Do they have any children? Are they supporting those children, paying for school and so on? Beyond the basics, of course, paying for food and rent or mortgage, among other things. If it happens to be a female client, are they currently pregnant? That's something that can go a long way towards a reduced charge or sentence, because we certainly don't want somebody who's pregnant, at least within reason, in custody, if that's something we can avoid, if we can avoid jail or prison time. What we do at DRD Law specifically, we actually subscribe to some different evaluation services so that we can present our clients in the best light possible. That we can show, listen, they're a human being. They may have made a mistake. Maybe they've even done something very serious. But again, at the end of the day, they're a human being. They should be given that second chance to get back to their family, get back to their loved ones, but also make sure that they've paid their debt to society. If that involves community service, giving restitution like we talked about earlier, if there's a way to make the victim whole and to pay a cost, both literally in terms of dollars and cents, but also by doing that community service, by maybe having to spend some time in jail or the Department of Corrections, but that it's less than what the state may originally be thinking, or less than what the charge itself holds. And what I mean by that is that a defendant can be charged with a felony, maybe even very high level felony, but through negotiation and providing mitigation, we can present them in a way that the state and the judge recognize that this is somebody who should be given a second chance, that this was an unusual set of circumstances. It's unlikely to repeat itself. They're willing to reduce, or it's a phrase you may hear your attorney, and certainly one I use all the time, a reducer, meaning we're going to go from a higher level charge to a lower level charge. So from a felony to a misdemeanor, or going from a more serious level felony to a lower level felony, so that the client is facing a less serious punishment for committing that offense, or at least pleading guilty or being found guilty. Mitigation really is brought up at two different phases of a criminal procedure. One is before trial, that if we're trying to resolve a case with a negotiated plea or a special program or something like that, we will, as the defense, provide mitigation to the state's attorney specifically and ask them to reduce the charge or to offer a specific type of sentence. And again, that's going through all of those factors we talked about earlier, presenting as many positive things about our client and the circumstances as we possibly can, and then working with the state's attorney to try to get that reduced charge. The other time when mitigation comes up is at a sentencing hearing. Now, a sentencing hearing traditionally is following a trial. If the trial was unsuccessful and a client was found guilty of one charge or another, we then have to go in front of the judge, and there's no longer any negotiation taking place. We're not going to the state hoping for a lesser charge or a specific sentence from the state. We're actually going straight to the judge, who is the one who's going to pronounce sentence or give out the sentence. And it's the same bit of mitigation. It's these positive things about a client, about a defendant, as to why they should get a lesser sentence, or why a judge could consider probation, assuming it's a probationable offense, or doing the low end of a sentencing range if we're talking about going to the Department of Corrections, going to prison. These are things that we can show to the judge. Typically, when we're talking about mitigation, it's actually putting together a packet of sorts where it's a number of things. It's letters of support from friends and family. Maybe it's from your employer or an educator. If you happen to be in a school or a program, they could talk about what you're doing in that program, what an excellent student you are, your participation record, what have you. If it's an employer, it's about your work ethic and how long you've been working at the company and how valuable you are and how they want you to stay employed and working there. It can come from a priest or a rabbi or somebody, if you go to church or something like that, again, that can talk about your participation at that church or in that community. It can come from volunteering. If you work at a special program, if you coach basketball or sports, if you read books at the local library, if you work with animals, whatever it may be, it shows that you're certainly more than what this criminal charge is and what's been alleged on that specific day. that you're this full fleshed out individual. You're a person. You know, you have a family, you have hobbies, you have things that you do in your life that we want the state and the judge to know about before they make an offer or before they sentence you. It's a very important process to get the best mitigation possible. And working with a seasoned attorney can help in that we know what a state's attorney wants to see. You know, what is persuasive and what might be a waste of time. What a specific state's attorney or a specific judge finds useful or helpful or persuasive. Different judges want to see different things or persuaded by different things or think more things or certain things are more important than others. And again, a seasoned attorney who has experience with a specific judge and with a specific state's attorney can provide that insight. It's something that I do every day. At the end of the day, mitigation is just good stuff about yourself. It's presenting yourself in the best light possible, fully fleshing out who you are as an individual, why you should be given that second chance or the reduced sentence or a reduced charge. That's something I can help you with. Certainly, if you have any questions about mitigation, either for yourself or a loved one, please contact the firm. I look forward to speaking to you in the future. Thanks a lot.